All right, I want to talk about a specific type of trademark recommendation that I make. And if trademark, you don't know what that is, you don't know what that is versus copyright or patent or intellectual property, go watch our other videos. Got a bunch of videos that explain what trademarks are, what copyrights are. For the purposes of this video, I'm going to explain the concept of when I recommend to clients that they should not actually pursue a trademark application to register a trademark with the United States Patent and Trademark Office, the USPTO. Now, the USPTO, because they're the ones that hold the keys to registration, they're the ones that let those applications through the gate and actually register trademarks through all 50 states in our country. And because of that, they have to take a very, very narrow stance on what can be registered. They look at two primary things: whether a mark is too descriptive and whether a mark is confusingly similar to another mark that's already been registered. This second category, confusingly similar, that's called a Section 2D refusal when the USPTO issues their refusal for similarity. And that's the one that's going to be the focus of this recommendation in this video. Essentially, what happens is the USPTO, the examining attorneys over there, they have to look and see if there are any already registered or already pending applications that are going to confuse consumers, meaning that the mark is so similar that a consumer out there, if they saw them both on a shelf or in a Google search, that consumer would not be able to differentiate those two trademarks being two different companies or two different services or two different types of goods. And in those situations, the USPTO is going to refuse that. That's that Section 2D refusal. And so, as a side note, pro tip, pay a lawyer to do a comprehensive search before you spend the hundreds and hundreds of dollars on a trademark application. Because if you spend a couple $100s on a search and you realize that you probably shouldn't file that application, you're definitely going to be in a better situation than if you spend a few hundred and file it. Because in addition, if you file a trademark application and you shouldn't have because there are too many similar marks or even just one similar mark out there, not only is the USPTO going to refuse that application, so it's money that you threw away, but USPTO applications are public record. And companies that monitor, protect, and police their trademarks most likely have alerts set for when people apply to the USPTO with a similar mark. And if they do, you're going to get a cease and desist letter like that. And so that's going to be another reason. Definitely don't apply. Definitely do the search first, because you can avoid all that hassle and all that expense. But I digress. So the reason that sometimes I will, after I run a search, recommend to a client that they should not actually apply for trademark registration. And keep in mind, I'm not saying here that if a client has a mark that's identical to another trademark registration mark out there, that my client should use that because that's trademark infringement. By no means in this video am I encouraging anyone to commit trademark infringement. However, the USPTO has to take that very, very narrow stance of what can register, and that typically means that some marks that are somewhat similar but not confusingly similar, practically speaking, may actually cause the USPTO to refuse an application. However, those companies that have those marks may not consider that to be infringement at all because their mark is just somewhat similar, maybe in somewhat similar class of goods and services to the mark that you'd like to register, but not to a degree that would likely rise to the level of trademark infringement. And that's the crux of this. The USPTO standards for what can register and what cannot are not going to be the same standards for what is trademark infringement. The USPTO is going to be more stringent than what qualifies as trademark infringement. So, again, not encouraging anyone to commit trademark infringement. However, sometimes that mark that you want to register is similar enough that the USPTO would refuse it, but not so similar that it would likely rise to the level of infringement. And in those situations, if you were smart and paid the money to do that comprehensive search and do that due diligence, most likely that's where your costs are going to end, if you're working with me at least, because we are going to recommend don't apply for that. The search told us everything we need to know. You're probably or most likely going to be safe using that mark. You're not going to get hit with infringement. But if you apply, you're going to spend that money to get refused, and then you may get a cease and desist letter from those companies that maybe would have never known about you otherwise because they're going to try to use that USPTO refusal as evidence of infringement and ammunition to come after you with a cease and desist letter. So again, not encouraging you to go out there and infringe on trademarks, but there are some limited circumstances where a mark is different enough that you would be able to use it without trademark infringement, but not different enough that it's going to get through the USPTO to be registered in all 50 states as a trademark. Hope this was helpful. Hope you have a good day. Don't know why I'm doing finger guns. Hopefully that doesn't stop you from tuning in again. See ya.